For pronouncement of judgment, item 1.
Let's see. Writ petition stands dismissed.
Item number 2.
Appeal stands dismissed.
Obliged.
Judgment. Supplementary list item 44.
Bail petition dismissed with liberty to petitioners to approach the authorities concerned under the state of the central government or the competent criminal court for launching investigation into the allegations leveled in the PI.
Adjournment request, if any, from item number 1 to 5.
The concern of the other side, I'm praying for mention of the matter, item 2 and 3, my lord. We need 3 weeks time to file a reply against the affidavit filed by the.
Who is for the other side? You need 3 weeks time on behalf of whom?
Respondent number 2 and 3, my lord.
And who is for this petitioner?
Second.
Appellant. Who is for the appellant?
Mr. Das.
Have you taken that?
Yes, my lord, we have taken written consent.
3 weeks at the request of Like, an adjournment slip is circulated with the consent of the counsel for the petitioner for adjourning the matter. Just after 3 weeks as per it by the counsel for the respondent.
Obliged.
Item number 6 to 17.
May I please, your lordship? I would like to mention item number 6, lordship. We have a advance adjournment slip
Adjourn.
and a similar prayer in respect of item number 8.
Adjourn.
Obliged.
Madam, may I pay a date may be fixed in item number 8, madam?
Ask the court master.
DPO.
May I please, your lord? With due consent from the appellant side, my lord, I beg to mention item number 13, my lord.
Adjourn.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 9, lordship.
9. Yeah.
Lordship, matter may be kindly taken up after 2 weeks. We are awaiting the instruction, lordship. May I like to withdraw the matter, lordship, but we are awaiting the instruction from the department,
You are for
income tax department, lordship.
income tax. Like a counsel for the revenue. Waste some time to seek instruction. Counsel for the petitioner, the revenue has submitted that probably the issue, probably the amount involved in this IT appeal is less than 2 crore and therefore is covered under the litigation policy. He prays some time to complete his instructions. Time prayed for is granted how much time?
2 weeks, lordship.
2 weeks.
Obliged, lordship.
Any other request? Daily list for admission item 1.
Your lordship, the leading senior counsel, Mr. Kent, is on his leg, so it may be possible for the time being, my lord.
Let him start. Ask Mr. Chaudhary to come.
Flush. Yeah, please, your lordship. Lordship, this Appeal is filed against an order passed by the learned single judge on 19/7/23, whereby lordship, uh, the petitioners were found to be entitled to be paid HRA at 20% with effect from 1/9/2008 to 36/2007, and thereafter at the rate of 16% with effect from 1/7/2017 onwards. That your lordship will find in paragraph 13 of the. Now, the whole case of the petitioner and the findings of the learned single judge are based upon the notifications issued by the central government, by which the HRA has been fixed. And if I may take your lordship to paragraph 11, there are basically two grounds were taken. One is the provision of section 33 of the Mizoram University Act, which I will address your lordship. And secondly, office memorandum dated 14/5/1993, which is stated to have been extended from time to time, and no material was placed before the court that this particular notification has been withdrawn. That your lordship will find it paragraph 11 of the judgment.
You just show us
Lordship,
this 14/5/1993 notification, page.
406. 406.
lordship will come to page 412. That is a part of their writ petition,
Right, copy it, sir.
and the
And another order, communication dated 11/12/2019.
That's it.
page 306. That 11/12/2019 lordship will find at page 571.
तो मेनू है हम लोग का शिलोंग में, वहां से ये कैंपस था। इन लोग का कैंपस था जब मिजोरम यूनिवर्सिटी हुआ इन्होंने इनका एक ग्राउंड है सर कि ठीक है 33 में इनको कंडीशनल सर्विस कंडीशन मिलती है, लेकिन इसमें 750% भी आती है वो एक्सपेंशन 2000 के बाद आया। अगर सर वो आपने बैठा हुआ उनको फिर वैसे बातों में एक ही जगह में दो जगह इसको ये है 270.
Yes, yes, yes.
Positive.
The under 70.
412 में जाएगी सर. Clear type. 12.
This is your justification for denying them.
Lordship, I come to that. Lord,
Come to this communication dated 11/12/2019. Page 571.
yes. No, before Lordship, before coming to this,
You just first explain this. That's why
Yes.
this explanation which you have offered in para number 222.
yes, Lordship.
Yeah. Read.
Yes, the department had agreed to grant HRA at B and Y class cities rates to the central government employees posted at Aizawl, Mizoram on the basis of various court orders only. What were those court orders? Well, we'll go to that.
Please read full.
Yes, however, this has remained limited to applicants in those cases only, and this benefit has not been extended to non-applicants.
What is this reason? Okay, yes,
No.
court- since the court has
No,
passed the
Lordship,
order, we are granting them, otherwise we are not granting them.
So far as the second part of this paragraph is concerned, Lordship, I would humbly state, Lordship, that this is perhaps not correct.
Perhaps not correct. You are admitting that since the court has passed the order, therefore we are granting them. And where the court has not passed the order, we are not granting them. We are passing the order, grant them. That's all. If this is the situation, what's the problem in that?
Lordship, let me address your Lordship. Let us go through the office memorandums, Lordship.
Which office memorandum?
First,
So what is this justification? You just justify us whether you can discriminate in this manner.
Lordship, so far
That
as
since the court has passed the order, we have accepted it. We are
Sir.
giving them the benefit. Here in these cases, the court has not passed the order, therefore we are not giving. We are
The-
passing the order, give in. Give
The-
them.
the orders that have been passed are not related to the Mizoram University, Lordship.
Sir, whatever it may be,
have-
central government employees are getting that HRA at,
No, that is-
applicable to the B,
No, that is what,
B2, this classified cities.
that is
Why
what,
these
that
persons
is
are
what
not-
my endeavor would be to impress upon your Lordship. That, let us see how it has started. It has started with 1993.
1993,
Let us see.
thereafter 2000, fourth pay commission, fifth pay commission, seventh pay
I
commission,
will,
sixth
show-
pay commission.
I'll
every year.
show your Lordship a document by which this benefit was withdrawn. I will show that, but let
Withdrawn-
us, let us
withdrawn.
first.
Where is
understand-
that?
Yes,
Where you,
but
where
Lordship
you
will-
argued before the learned single judge that benefit was withdrawn.
the predicament is, Lordship, no argument was advanced before the learned.
Then please, sir, either file a review petition. We are not supposed to go into all this controversy. The learned single judge has relied upon these two, this communication, has taken into consideration this communication and simply said, "Okay, yes, since they have not approached the court, therefore you are not granting, this is not a justifiable reason."
The learned single judge has also held that the office memorandum of 1993 has not been amended.
2008, it was 1997, I think, so it has been amended. It's there.
Let me show your Lordship. Let me show your Lordship. If your Lordship will come to page 414 for a moment. The basis of
So
the,
show from your reply or your arguments that it has been amended.
I'll show from their documents.
Their document you
Their
can show,
documents.
there is your argument that it has been amended and therefore has no application. You became wiser now and raising the grounds which have never been taken before the learned single judge.
Lordship. Now, Lordship, that is one thing I cannot, because
So then, sir, there is no,
But-
that is one thing, that is the only thing.
I,
If you have not raised and not considered by the learned single judge, how this judgment is wrong, sir? We are in the writ appeal.
Lordship,
You are not hearing the original writ petition.
that is, Lordship, correct, but
There are limitations.
I'll just show you, Lordship, one document,
You
which
show us as many as documents you want.
Lordship will come to page 678 for a moment.
678.
678 for a moment.
Yeah.
Now, if I may read paragraph 2. Based on the recommendations of the Sixth Pay Commission, the earlier classification of cities have been revised. A1 to X, A, B1 and B2 to Y, and C and unclassified to Z. C and unclassified to Z. In determining the revised classification, the population of urban agglomeration area of the city has been taken into consideration. Accordingly, the rates of house rent allowances shall be as under. So this is a notification office memorandum of 2008. Now, Lordship will come to the next page.
Now, where you this cited this notification before the learned single judge?
No, Lordship. That
Like आपको नहीं दिखता है उनको, but जैसे देखी देते, के बात का होता है.
if your Lordship will come to the next page, please. Paragraph 6.
Yeah.
The following orders have been issued by this ministry in the past to grant of HRA CCA at higher rates to the central government employees posted within the municipal area. Now, Lordship will come to serial 12 and 13.
Yes.
OM number so and so, dated 5/2/90, that is HRA at A, B1 and B2 class rates in Shillong. OM number so and so, dated 6/4/78, HRA at C class rates in Hill Station. Now, these OMs have a mention in the office memorandum of 1993 at page 414. At page 414.
Yes.
Now, Lordship will see the right-hand side column. Somewhere in between, The orders listed at serial number 6 to 13 in the margin issued by this ministry related to HRA, CCA, to central government,
Where you are reading?
page 414, Lordship,
414.
414, Lordship.
Yeah.
The right-hand side column. The orders listed at serial number 6 to 13 in the margin issued by this ministry relating to HRA, CCA to central government employees posted in cities, towns, hill stations covered under these orders, where HRA, CCA has been granted not on the basis of classification of these cities, towns, as per the population criterion, but on special reasons, shall also continue to be applicable until further orders. Now, your lordship, this 12 and 13 lordship will see in the left-hand column. These are pertaining to those I have shown.
Shillong.
Shillong and other hill stations. If I may read the next paragraph, lordship, of page 679.
Yeah.
However, due to inclusion of Navi Mumbai within the UA of Greater Mumbai as per 2001 census, placing of existing C-class cities, towns, as well as unclassified places under new category Z. 3, abolition of CCA. 4, upgradation of Jammu, Kolkata, and Chennai on account of inclusion of UA. The special dispensation shall continue to be extended only to the following cities: Faridabad, Ghaziabad, Noida, Gurgaon at X class city rates, Jalandhar, Cantonment, Shillong, Goa, and Port Blair at Y class city rates. In the meantime, in between 93 and 2008, Aizawl, Mizoram was placed in C category or Z category. Now, it will be extended only to Shillong, not to Aizawl. So that benefit which was given in 1993 stood withdrawn in 2008. And the decisions which are taken into account, lordship, those decisions are prior to 2008, lordship.
That's all.
Lordship, I would be basically relying upon the change in 2008, lordship.
The order is up.
Supplementary list, item 45 to 57.
ऐसे फिर भी पति कोट्रिया में फिर 45 रहते हैं वो तो वहाँ तुम्ही असं इसकी थोड़ी सी ऑफिस हो जाए वो मतलब कहाँ है तो वहाँ मैं खुले इसमें कैसे I might be the matter we are going to responsible. You are also submit the letter for
Why written submission? We are not hearing the matter finally. Which
one.
item number 1? Okay, ठीक है. Okay. Yes. Who has mentioned this matter? What's the urgency? In some of the matters, even service has not been completed.
Lordship, I have mentioned I am appearing for only 3 matters. Sir.
The 3 matters, we'll hear all these matters together,
Yes,
sir.
yes, but Lordship, I am also in all other matters I appear before the AFK. Even in the, but I could not contact with them also because of the ethics violence problem and
No, it may be so. That, but this, now it can't be heard in this manner. We have to hear about
Yes, Lordship.
all these matters.
Because
Why
of
you
the.
are mentioning in these matters, sir, isolated, करके, how can we hear all those?
I had mentioned it because in which items I have equity Lordship, they have been saying that because of the disability eligible potential.
Naturally, sir,
So
it's
that's
a
why,
matter we have to
I
decide.
made it.
Take a call.
Otherwise also, Lordship, though these matters are of disability pension, but matters are different. Tax are different, Lordship, so.
Here, but since we have connected all these matters, the matters are to be heard together, sir.
Yes, Lordship. If we go one by one, Lordship, they must be okay.
Jan,
Hey, affidavit of complete.
the model is ready to continue in all these petitions till next date.
Oh.
May last में लगा तो कुछ हो जाएगा. Yes.
Item 58.
Yeah, I had some, I just requested, subject to lordship convenient, if this can be taken up on Monday, my lord, if possible. There is some urgency on the bank side. I was ready with the case, but I have some personal difficulty today. I just requested, subject to your lordship convenience,
Monday.
Monday.
On Monday.
I'm sorry for troubling, my lord. I have gone through it, my lord. Your lordship has said that I have to argue on this matter.
Yes.
This is a very gray area, I am telling your lordship.
Whatever it
I
may be.
found a judgment of the court, which your lordship indicated of the Supreme Court judgment, that also I have gone through it. 37.1, I just indicating 37.1 of the judgment has carved out where to go and where not to go. That's been carved out 37. I'll just explain to your lordship.
Okay, at the request of the learned counsel for the petitioner, list this matter on Monday. Interim order if any to continue till next week.
I'm deeply obsessed. Delay next week. Monday.
Daily list for hearing item 4 and 5.
Malo, the issue involved in this case is land was acquired for the IIT.
When was?
Land was acquired.
When the award was passed.
Malo, yes, award was passed on 31st of December 2013.
Satisfy us on that.
Well,
point. That's all.
Malo, learned,
On this point only.
yes, learned trial court says that award is to be approved. The act says after approval, the award is to be passed. So it is not the approval of the award itself. It is the approval of the approval before award is passed.
Approval before award is passed.
Yes.
And
Now,
the-
Malo,
And the language of section 11 is?
yes. Language of section 11 is no award can be passed without prior approval.
1894.
Yes, ma'am. Proviso, my lord.
Yes, I will look. Land acquisition Act 1894.
Land acquisition, right?
What happened when they collect without the previous approval of the police, approve they were not present that year. That's it. So, they were in the-
Yes.
Then also, without such approval, and there is one society. Yes, they gave some giving of we see control percentage earlier estimate in respect of application under in connection with the aggregation of so and so. So, this is data. Not talking. Equalization 6 in respect of published on so and so, they estimated 71% only. Details of which is shown in the audit, but given you can make and be approved, given rest at given. Receipt alien Kamru, Kamru per submit the award in respect of the number, etc. Into one example. The compensation amount. Award in respect of in connection with the acquisition of the land. So the amount of only may be approved. Now, I mean, okay, if it is 191 the second portion of the page in the this is complete the earlier estimate. Now we have two issues to all concerned. This is the commit dimension. The dimension already agreeing with some physical competition. We also provide also নতুন একটু দিয়ে দাও Acquired amount in 2002 and the end of estimate case has already been 9/1/2002. Relevant portion of the so in respect of has also been ACS. This is submitted the earlier estimate insurance percent. So ये इस बार अच्छा ये अलग-अलग बाकी अलग ओके तो ये सारे अप्रूव हैं हमारे वो yeah, definitely. This one I expected the total potential. Letters were issued early. Expect of no change. Approved by the minister consent. Suppose the estimated the award of emission was submitted by the director on service. But we not achieve the approval of the if not one percent as approved. Approval of the award can be calculated with the goal of the
For such a when they hear all the public official will come to them for the appropriate this is without such approval in such a class of business that the ये बता दो कहीं ना
Lordship was inquiring about section 11. Proviso says, provided that no award shall be made by the collector under this subsection without previous approval of the appropriate government. So there has to be a prior approval for the award. Now, in this case, my lord, approval or award was signed by the collector. It was sent for approval. Approval was made on 31st of December 2013.
Show us.
No, I'm coming. Lordship will kindly bear with me. The records were examined by the learned signature. Learned signature says refer to those letters where it is mentioned that it was approved on 31st December. Learned signature has proceeded further to say that after that, on 9th of January, the award was approved. But approval of award is not necessary where it is signed award is sent for approval. And if the approval,
Show us the law
my lord,
on this law. Show us the law.
this is my lord, and this has been mentioned in the learned signature judgment also.
Fine. Show us the law.
My lord, page 2006 2 SCC, page 416.
2000.
2006, well, I've got a copy. 2006, volume 2 SCC,
Volume 2 SCC.
my lord. Page 416. Bailamma versus Purna Prajan House Building Cooperative Society. Para 25, my lord. Page 416.
Read.
My lord. The collector is required to hear the persons interested and inquire into the objections, if any, raised by them on points which he is required to determine. It is possible to conceive that he may hear the objections on several dates having regard to the number of objectors and the nature of the dispute that may arise, whereafter he must make up his mind and prepare his award. It is not expected of him that he should prepare his award in presence of the persons interested, since the collector may take some time to make up his mind on the matters he is required to incorporate in his award. Thereafter, he is required to send his award to the government for approval. The approval of the award may take some time, and it is not known to the collector as to when the government will approve the award. However, after the award is approved, if there is no alteration in the award, he is required to notify the parties concerned about the award. He may do so by fixing a date on which the parties may be required to appear for pronouncement of the award, or he may inform them by giving them written notice of the award. This is because an award is in the nature of an offer and must be communicated to the persons to whom the offer is made. There is nothing in section 11 which expressly requires the collector to announce his award in the presence of the persons interested, though there is nothing which prevents him from declaring the award on a date fixed by him for the purpose. However, having regard to the provisions of section 12(2) of the Act, he must give immediate notice to such of the persons interested as are not present personally or by their representatives when the award is made. Thus viewed, there can be no doubt that after the award is approved, the same becomes an offer to be made to the persons interested, and this can be done by either giving notice to the persons interested of the date on which he may orally pronounce the award, or by giving written notice of the award to the persons interested. The question of limitation for filing a reference under section 18 or section 30 of the Act has to be determined by reference to the date on which award was either pronounced before the parties who were present, or on the date of receipt of notice of the award by those not present. The mere fact that collector did not pronounce the award after notice in the presence of the parties interested will not invalidate the award, though it may have a bearing on the question of limitation in the matter of seeking a preference under section 18 or 30 of the Act. The award, this is important, the award which was already been signed by the collector becomes an award as soon as is it approved by the government without any alteration. At best, the appellants can contend that it becomes an award when notice is given to the parties interested. Viewed from any angle, having regard to the fact that there is no dispute that the government granted its approval on so-and-so and notices were issued under section so-and-so of the act on so-and-so, it must be held that award was made within the period prescribed under section 11A of the act. There was really no necessity for the collector to sign the award again, nor does section 11 require that for the purpose of pronouncing the award, notice should be given by the collector to the persons interested. Section 11 requires notice to be given for the purpose of hearing objections. After the objections are heard, the collector has to apply his mind to all the relevant facts and circumstances and prepare an award. Whereafter, he is required to send it to the government for approval. There is nothing in section 11 which requires him to give notice to the persons interested of the date for the pronouncement of the award. So my submission before Lordship, my Lord, in this case, if your Lordship goes to the page 195, Lordship will find all the records were examined by the learned single judge and letters are also.
Yes. Para 32 of the improved judgment.
Para 32, my used. Yes, ma'am. I am reading, madam. It is further observed that an award shall not be made by the
No.
collector.
Para 32, sir. Para 32, this is next, इसी पे page
Yes,
20
yes,
जाएंगे,
yes, yes,
after-
yes. The note sheets demonstrate that Deputy Secretary had put up the notes on 9/1/14 in all the three cases, indicating that the awards had been submitted and the same may be approved. The additional Chief Secretary, Revenue and DMLR Department approved the same on 9/1/2014. My lord, this is
Read.
absolutely. In all the three cases, and thereafter letters were so-and-so had been issued, forwarding a approved copy of the awards in respect of the three LA cases. Therefore, the only conclusion that can be reached is that the awards in question having been approved by the government on 9/1/2014, the awards cannot be said to have been made on 31st December 2013. Thus, the awards were made after coming into force of the
Simply,
2013.
though you have signed the award,
My lord.
but the government has approved in on 9/1/2014.
No, my lord. Government has approved. My lord, what has happened here? My lord, I'll show from this. Signed copy of the award was sent to the government. Lordship may kindly see page 209.
Okay,
209, my lord.
two zero nine,
209, yes.
which case?
This is, my lord, 208. Writ appeal 208.
Part of the judgment.
Yes, ma'am. Yes, internal page 27, my lord.
Yeah,
Yes. Yes. My lord, may kindly see. These letters are, there is one letter of 9/1/2014. Then next page again, 2009. Extracts of note sheets go to show, etc. Page 200, Lordship, you kindly see. April, page 2, internal 19.
Yeah.
2000 down bill Lord, can say approved 31st December 2013.
What was sent for approval, sir?
My lord, what was sent for approval is the award,
Now
signed
read-
award.
Read.
My lord.
DC Kamrup has submitted a LA estimate in
Yes.
respect of LA case number in connection with the acquisition of 27 bighas of Lesa so and so. Declaration in respect of so and so, LA estimate amounting to rupees so and so. Only details which is shown as the office note 3 page may be approved. This is the estimate they have approved.
My lord, 201, Lordship, can you see this letter in between? Now we may perhaps, page 20, my lord, in the middle. Now we may perhaps approve the award with the approval of the additional chief secretary, that is of
The
31st
additional
December.
chief secretary objection has been submitted, what is so and so. Now, where you are reading?
But
Now,
page
we may perhaps approve with the approval of the
Award.
additional chief secretary. Okay.
award was, madam,
Then-
my submission is, my lord.
So,
My lord,
now come.
my,
This, the LE, this page number 19, है ना, judgment,
my lord,
internal page 19.
yes,
The LE estimate amounting to rupees 2 crore 60 lakhs, so and so, so and so, details which is shown as being may be approved, may kindly be approved.
yes,
Okay,
yes,
may be approved, then we come
Then-
to next page.
yes,
31st of December, so and so, Deputy Secretary may kindly be seen. The additional Deputy Kamrup Aminga has submitted a settlement of around 236, so and so. You do LA cases, sir. Hmm? 11, 11, 11. Yeah. The additional Deputy Secretary Kamrup Aminga has submitted an award statement amounting to rupees 2,36,000. 2 crore 36 lakhs 60,000. And this was of 2 crore 30 lakhs 383.
yes.
Amount was changed. Why?
Along with the preliminary council, the deadline to deliver of the submit. Award is able to will be signed in this also. Acquisition for section or ID and whether so regarding a real person, the people is the one car. Yes. 25 may be declined. From the above, it appears that 3 letters, 91 from the paper which transfer about in respect of I'm directed to forward areas and approval of the accounting. In connection with the acquisition of land along and houses in the yeah, that is sorry. Government of Assam revenues also. Two award in this one. ये दूसरे के दूसरे के 11 the government of revenues of note to information in the role of better local and acquisition tool of the estimate. The government is not one is coming out very fast.
They know. That's all, sir.
My lord, page 207, internal page 26 may kindly be seen for a moment.
Yeah.
This page refers to the letter dated 9th of January 24. Subject is approved award in respect of LA case number 1 of 2012. Then the body says, I am directed to forward herewith an approved copy of the award. Before it is signed on 9/1, it is said that it is approved copy of the award. Now, if the award was signed by the collector, my lord, if your lordship examines the record once again,
Approval.
my lord, what
There
I
is
am,
the approval
and only,
on 31st
my lord,
of December 2013 approval.
my lord, my only one submission I have in this case, if the award was signed by the collector before 31st of December and it was approved,
Where is the approval?
my lord, this is what I have shown, my lordship is in page 195. Approval is of 31st December 2013. If necessary, my lordship will examine the record once again, just.
Statement along with the information of the award statement is along with this one, so it's only signed by the commissioner in connection with the application of the also. कौन सी तारीख
ये 31 को ये जाके ये
My submission is the finding in para
Sir, again
32.
we are asking approval, approval, approval. Yes, the award was submitted, signed award was submitted by the collector before the
Cut-off date,
on 31st.
my lord.
That is the last date.
My lord. And if it was approved on that day itself,
Where is that?
my lord, this page 195, it says, my lord, 31st December 2013 approved.
Where is that?
Page internal page 14, my lord.
14.
My lord.
14?
In the middle of the file, approved 31st December 2013. ADC Kamrup has furnished award in respect of LA case number Swin. So see, if the award was submitted by the ADC prior to or on 31st December,
Page 16.
ये award approved. ऐसे कुछ लोग पहले आगे इसको कुछ पे
ठीक है
आओ क्या
So,
That's all. Just one submission.
yeah,
Possibly your lordship is not satisfied. That's why I will like satisfy your lordship. The finding in paragraph 32 is that award is to be approved. It is not the award which requires approval. It is the requirement is there should be prior approval before the award is made. And if paragraph 25 of the judgment is taken into consideration, my lord, if the signed award was sent for approval, moment it is approved.
so the approval was on 9/1/2024.
No, my
That's
lord,
all.
no, my lord, this is the problem. 9/1, the subsequent, there was,
The estimate was for a higher amount.
yes,
Subsequently, on 31/12,
my lord,
Deputy Commissioner sent a signed award.
yes.
That was approved on 9. If you see your notes.
That's a finding of fact, sir.
No,
Ultimately,
if it is a finding of fact, I'm not going to challenge it. I'm not saying that. What I'm saying is, my lord, learned single judge was of the view, it's very clearly contrary to what Honorable Supreme Court has said, that award is to be approved.
this is not the learned single judge. Page para 32.
Yes, my lord. Lordship,
Yeah.
you kindly see.
Yeah.
The note sheets demonstrate that Deputy Secretary had put the notes on 9/1/14 in all the three cases, indicating that awards had been submitted and the same may be approved. The Additional Chief Secretary, Revenue and DMLR Department approved the same on 9/1/14, approved the award in all the three cases. And thereafter, letters dated so 9/1/14 had been issued forwarding approved copy of the award in respect of the three other cases. Therefore, only conclusion that the award can be reached is that awards in question having been approved by the government on 9/1/14. So, learned single judge possibly was of the view that since the award was subsequently signed by the Additional Chief Secretary on 9th January,
Award, there is no question of signing by the additional chief secretary.
it
Award
will
is
be
to be signed by the
collector, yes. My lord, approval of the award. Learned single judge is of the view that award was approved by the Additional Chief Secretary on 9th January.
That is
My submission is, my lord, these documents which are announced, not very clear, but it shows that signed copy of the award.
not very clear. Then what shows, sir?
No,
Not
my
very
lord,
clear. Then what is there to show?
it doesn't lead to the conclusion that the award was not sent.
There is no irresistible conflict. Order reserved. You are for
Private respondent in both two cases,
two cases in these two cases.
185 and 208.
Shall we record your presence? Because we have not heard you.
Some documents,
What
document development,
What development? What are those documents?
Mark Annexer A.
Yeah.
This is government has decided to comply the order of the honorable single judge. And
When?
it was on 14/12/2023.
To continue the writ appeal.
Who they gonna get this then?
And
So,
B is the award, revised award, which was prepared by the deputy commissioner. Amount rupees 14 crore 80 lakhs to the petitioner. And annexer C is the reminder to the government.
Hmm.
And annexer D, this is the proposal to contingency fund for the
why revised?
revised award.
Acha, revised karke. But at the same time, they are saying that we'll continue with the writ appeals.
Lordship.
Look here.
Neither here nor there, my lord.
That's the only thing.
Only thing.
What is it?
Oblige.
My lord, I am taking liberty. My lord, item number 1, actually I was in the midst of a pattern matter in post numbers going on. My lord. Deep.
Your presence is required to be noted, or your presence is to be noted, or
I leave it to your lordship.
no, you just said us.
Noted.
Noted, okay.
Item number 7.
Order 2 weeks.
Huh?
What the extra? Order 2 weeks.
This,
It
have you
says the
decided?
approval of the law minister. Approval of the law minister. Order 2 weeks.
Approval of the law minister? With reference to the subject, I am directed to inform you that relevant party direction that the underworld of being proceeded for approval of the law minister and chairman which will review the same time. So what you have decided ultimately? Whether she is entitled for
Fast speaking order, my lord.
speaking order may, you have to decide whether she is entitled for that pay scale of record keeper or record arranger.
It's not clear.
Not clear then, in fact, on February 2024, there was a letter on your part, we were not aware of this and we'll immediately do it. Now it's more than a year. What you are doing?
Order 3. The last sum order. It's the last sum.
Shit. Yes. So how you are agreed by this order?
Lordship, my senior is in leg at 414.
All your senior. All your senior. Pass over for the time being.
Item 10.
वो सारे पूरे सीरीज के साथ ही जाएगा 16
Item 11.
11.
10 to
10
सीरीज के साथ ही आएगा
May please, Madam.
May I please go ahead? In this case, my lord, I have filed in KBL myself. Thereafter, my lord, the petitioner is living in a remote place of Majuli, my lord. I have failed to communicate with her, my lord. Thereafter, the KBL has been discharged, my lord. Thereafter, on my lord, advocate here, my lord, but without any wakalan number. Very recently, my lord, she was suffering from some, my lord, major, my lord, health issues. Thereafter, my lord, I have communicated with her. So they are able to enable me to file a Wakalan number. Can it be possible to give me only 1 or 2 days, man, to file my Wakalan number? At least
have you gone through the this case?
my lord, some records.
His provincialization was not under challenge. How the learned single judge interfered?
He knows everything. He was the
Go
advocate.
and approach the tribunal if you are agreed by his provincialization.
No, my lord, here the fact hearing is that, my lord, that even though, my lord, what they are doing there, my lord, that considering the aspect that the headmaster, the respondent number 3, he is projecting him as, my lord, all subject teacher, my lord.
Sir, in fact, in the writ petition, you have not challenged his provincialization.
Fine.
The learned single judge on his own has set aside that provincialization and relegating others to approach the tribunal. You approach the tribunal and challenge his provincialization.
No, not tribunal, my lord. I have been directed to file an appeal before the, my lord, that is director of
Oh, sorry, not tribunal, the appellate authority.
appellate.
So,
The appeal has been dismissed, my lord. The appeal has been dismissed. I'll point out the modus operandi, my lord. My learned friend, I'm the appellant, I have the right to begin, my lord. My learned friend had appeared as the advocate in the writ proceedings as well, my lord.
okay.
After filing the appeal, my lords, on the first day, the order dated 15/5/23, it is submitted that Mr. B.K. Das, that is the learned counsel, my lords, appearing on caveat submits that he is not desirous of acting on the caveat as the respondent number 1 has not given any instruction to appear in the case. My lord may peruse 15/5/23. Thereafter, my lords, we had to take dusty steps twice, my lords. Willingly, he did not appear. My lordship may peruse the order, my lord. 15/5/23 filed in the IA, my lord.
IA.
IA 1244.
It was with a delay.
Yes, my lord.
Acha.
So he appeared on caveat. On the first day, he submitted that I'm not willing to appear. Thereafter, he does not appear. I take dusty steps twice. Takes me 1 long year, my lord. Thereafter, all the hearings, he does not appear. Now, on the final day, when the matter is fixed for hearing, he comes and he prays for an adjournment. My lord would see the conduct, my lord.
Only 1 day, man.
Not
And-
not at all. Not even for an hour.
The appeal has been dismissed, my lord. He preferred an appeal in terms of the order that has been dismissed. Yes.
What his provincialization.
Yes. Again, cancel, my lord, after the appeal. Appeal from the-
No, my lord, one thing, just with all due
Okay.
respect, I would like to, before your lordship, when this, my lord, honorable court has, my lord, stated that rightly or wrongly, my lord, that state aside the provincialization of the respondent of the six, my lord, thereafter that order has been under challenge. During the sale, my lord, where the matter has been my lord, subsidized, that when the, my lord, that the provincialization is or state aside, and even the before this honorable court, that single judge order was subsidized, that authority has, my lord, without mentioning anything about the appeal and the subsidization matter, at their own whims, they have, my lord, that they again they recommended the name of the, my lord, respondent number 6.
Here by this order.
My lord,
Challenge this order separately.
It was challenged, my lord. He filed an appeal pursuant to that order of the single judge. He filed an appeal before the director, my lord, section 14, and that has been rejected, my lord. That I placed the copy, my lord. He has to challenge that now, my lord.
only,
Yes,
Yeah, challenge
Yes.
this order of the
he has to
director,
challenge
sir.
that, my lord.
no, my lord, I just want to, my lord, just submit before the court with all due respect. When they find a court, my lord, as competent court, and honorable court, has set aside, that has not been, my lord, that is under challenge and matter is subsidized.
Which one?
My lord, the provincialization order of the respondent number 6.
So,
So, my lord, when his provincialization one order was set aside, that is, my lord, that the honorable court is superior to this, my lord, the director. The director had, how the director had again, my lord, recommended his name.
My
Considering
lord,
him
that's
against-
again I'm the appellant, and I'll point out when my lord had granted a stay order when I filed the appeal, my lord had stayed the cancellation of my provincialization, but my lord had said, my lord, it would go, that representation would go. You apply and that I leave it, I give liberty, my lord. Accordingly, he filed an appeal. That appeal is rejected. Now he has to challenge that, my lord.
I do not understand that logic. I apologize. When the provincialization order of the respondent number 6 is already set aside by the honorable court. This order was not, my lord, this order was not set aside.
8/5/2024 order.
Yes, ma'am. That's when the provincial, how the director can again recommended his name.
You are appealing for respondent number 7 here.
My lord,
No, one, my lord, one. The writ
One,
petition.
okay. Taking into consideration the facts and grounds, we deem it appropriate to direct the order passed by the learned single judge, setting aside the provincialization of service of appellant is stayed.
Yes.
It is made clear that the chairman of state level scrutiny committee is free to proceed with the representation if any filed by the respondent number 1 pursuant to the liberty granted by the learned single
And he
judge.
filed that appeal thereafter, my lord. That is rejected.
The order of setting aside, but the line of single judge order was not set aside as on date, my lord. This matter was subsidized.
Now we
That
set
is-
aside. That is the only requirement. We will do that.
Another respect, I would like to draw your lordship kind attention on. My humble prayer is that the fact of the case is very briefly that the petitioner is a social science teacher, my lord, and it has been, my lord, submitted by this. My lord.
Sir,
That has been taken care of by
If your claim for provincialization is rejected by the appellate authority, go and challenge it in separate proceedings. How we can look into all this, sir? We are simply concerned by cancellation of his provincialization. That's all.
No, my lord, well, the provincialization order of the private person is already set aside. That's the day who
That
has
has
to
been
comply.
stayed.
My lord,
That has been stayed by this court, sir.
my lord, it's set, but not fully set aside.
Will Abhi, just now we'll do that. Why don't you? This is the only
Another
requirement.
respect.
Okay, okay.
Now, my lord, just for a moment.
Okay, yes,
With
you
all
want
respect,
that, it
please
should
just-
be-
I would like to clarify one thing, my lord.
We'll do it now.
My lord,
We'll
it is
correct
your-
this
it
mistake
is-
now.
It is your lordship decision, but what I'm
And,
trying to say.
since you have pointed out it has not been fully set aside, we'll set aside. Don't you
It is
worry.
the
Why you
decision
are
of your-
worrying?
Decision of your lordship, but what I'm trying to say is that, my lord,
Discretion on your asking, we are doing it.
my lord, one aspect, my lord, my lord, that the sending this, all this, my lord, under section 14, my lord, that provision as far as, my lord, act, that is, my lord, not against the appointment order. My lord, that is, my lord, against the recommendation made by committee. Here, my lord, in the writ petition, I am challenging the appointment order of the private respondent.
Which writ petition?
In the writ petition,
That,
which is,
that writ petition is decided.
my lord, decided.
We have not challenged this order.
No, my lord, I am the
That's
appellant.
all.
Because
It's attained finality.
my lord, only the my last one thing. if you remember.
इनको जो मांग रहे हैं दो भाई.
हाँ, ले लो आप please.
दो.
Appeal. What has my lord got?
So just for a moment, my lord, take the 26, page number 26.
26.
26. Today only I have gone through this order, my lord. I found one specific, my lord, that some, my lord. My lord,
26.
page 26,
You mean
my
to
lord.
say that impugned order?
Impin order, my lord. Second para, so considering the above, the provincialization of service of the respondent number 6. So that, second para, my lord.
Yeah.
That is, his service has been, my lord, respondent number 6, his service has been, my lord, set aside. Thereafter, my lord, on, petition, my lord, thereafter, this, para 3, my lord, as such. As such, the petitioner as well as the respondent number 6 may be preferred. So, my lord, it is, that service of the respondent number 6 has been provincial and he have been again directed. So, my lord,
Not directed.
my lord,
Maybe.
maybe, my lord.
Maybe if he desires so, maybe he may
I've
not.
challenged the order. My lord, why will I?
There may be some clerical or something, but a mistake may be there. Because the
Inadvertent mistake by whom?
by my lord, maybe my lord, by the learned single judge.
So challenge it or challenge this order.
I will have to file.
You have not challenged it.
My lord, that today only I have come to know.
Huh?
And here, my lord,
Today only you came to know.
my lord.
Okay, then now challenge it.
So, my lord, we are facing the problem here that when this, that, my lord, our proposal of.
The problem is that we are facing the problem what you want.
My lord,
You have not been able to convey us what you want with us.
my lord, especially the section 14 does not provide for any appeal because right to appeal is an statutory right. The statute does not says anything about that there is no any provision for appeal against the order of the appointment. That is the.
So basically you mean to say that the order of the learned single judge is bad?
My lord.
Then we'll set aside. He is also praying this.
My lord, we are because
So you are on the same page.
authorities have said that I am the social scientist, sir.
You are on the same page. He is also seeking, he is also saying this order be set aside. You are also saying order be set aside. We need not to go into the merits of the case.
My lord, because
Because both the counsel for the appellant, counsel for the appellant as well as the counsel for the respondent number one is submitted
No,
that
I am not
the
defending my lord.
order passed by the learned single judge is
What is the,
against is illegal and therefore it may be set aside. Since both the parties are agreeing, order is set aside. This is the only order will pass. That's all.
because what I am trying, when the status, the court is set aside, spite of that fact, my lord, they are again recommending the same thing. And my lord, that the recommendation, my lord, I am not against the recommendation, my lord. I am against the, my lord, appointment. His appointment was set aside. thereafter,
Please,
my
you
lord,
just
okay.
you clear in your mind.
My lordship,
You are challenging this. You are opposing this
My lord,
appeal, or you are supporting the judgment of the learned single judge, or you are opposing the judgment of the learned single.
I'm supporting, my lord.
You are supporting, na? Then argue in the support. Why are you arguing something else? Okay, but the learned single judge should not have done this.
Substance that, my lord, what is the activity that has been by the, my lord, department? When this matter is subjudiced, a person's, my lord, appointment has already been set aside. Again, my lord, they have recommended.
Because this court has granted liberty to them. Why date 5/2024? It is made clear that the chairman of the state level scrutiny is free to proceed with the representation if any is filed by the respondent of one pursuant to the liberty granted by the single judge. We have granted him liberty, or we have made it clear. He has to proceed.
May I file a review petition before the learner single, because I have wanted of this.
Sir, whatever you, how can you are asking for our permission? No. We are not granting you permission. Then
I will have to seeking ideal, but apart from that.
No, you need our permission for that.
My lord,
You do whatever you want.
my lord, because.
And if we say no, you will not file.
If it is dismissed by this court, my lord, there, my lord, it is difficult.
Huh?
Or the single judge to consider, if you will anything.
Nothing. That's all.
So, my lord, just my lord, lordship may kindly is possible given an consideration that as per this, those, the orders that I have submitted, they to be kept in evidence.
Which order?
My lord, that's passed by the,
Is, whose appeal is this? Is it your appeal?
it is not my appeal, my lord.
Huh?
But the authority is acting as a matter, my lord.
Yes. बात कर रहे हो आप?
My lord, I'll just make one line submission.
पहले order सुन लो उसके बाद में.
हाँ.
This writ appeal is preferred by the appellant being agreed with the order dated 162, order dated 14/2/2023 passed by the learned single judge in WPC number 1623/2021, whereby the learned single judge has disposed of the writ petition preferred on behalf of the respondent number 1 herein and granted herein and granted liberty to the respondent number 1 as well as the appellant to prefer appeal before the chairman state level scrutiny committee forthwith along with the scrutiny level committee, full stop. It is further directed that in case, in the event of filing such appeals by the respondent number 1 as well as the appellant, the concerned appellate authority shall dispose of the said appeal within 90 days from within 90 days with a reasoned order after verification of the relevant record and after providing opportunity to all the concerned. Full stop. The brief facts of the case are that the respondent number 1 has approached the writ court by way of filing WPC number 1623/2021, claiming that she was teaching social science to the student of said ME school. However, when the matter was taken up for consideration of the provincialization of services of the teaching and non-teaching staff of the said ME school under the provisions of Assam Education in bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2016 as amended, the name of the respondent number 6, 7 and 8 were considered by the authorities concerned and were provincialized under the provisions of said act, disregarding the better claim of the petitioner. Full stop. The learned single judge, after noting, after taking into consideration the counter affidavit filed on behalf of the appellant, filed on behalf of the respondent in the writ petition, and after hearing the learned counsel for the parties, has ordered for setting aside the provincialization of the appellant only. However, so far as regarding the claim of the petitioner, claim of the respondent number 1 is concerned, the learned single judge has relegated her to approach the appellate authority, that is state level scrutiny committee, to substantiate her claim for his or her claim for provincialization as prayed. Full stop. The learned single judge has at the same time has also kept it open for the respondent number 6, for the appellant to approach the state level scrutiny committee. Full stop. Learned counsel for the appellant has submitted that, as a matter of fact, the respondent number one in the writ petition has never prayed for setting aside the provincialization of the appellant, but the learned single judge, without the learned single judge uh, has ignored ignored the same, and has illegally set aside the provincialization of the services of the appellant. It is contended that, had the provincialization of the appellant was challenged, he would have, in the writ petition, he would have submitted his defense, but without providing any opportunity to defend his provincialization, the learned single judge has illegally set aside the provincialization of the appellant. Full stop. Learned counsel, full stop. Learned counsel has therefore prayed that the impugned order passed by the learned single judge, to the extent of setting aside the provincialization of the appellant, be interfered with, and the appeal filed by him, filed by the appellant, may kindly be allowed. Full stop. Per contra, learned counsel appearing for the respondent number one has submitted that your submission, we record what submission, that you are also saying that the judgment of the learned single judge is bad?
No, my lord.
So,
Uh,
as opposed the, per contra, the learned counsel appearing for the respondent number one has opposed the writ petition. Yes, what do you want to say? What do you want to say? Nothing, you are supporting.
Support for yourself.
Learned counsel for the respective respondents has opposed the appeal. Having heard the learned
तुमने
counsel
oppose
for the
करना है
party-
नहीं तो?
Not open the appeal law. The order is not against me, Lord. The order is against me.
state nobody is clear. What do you, respondents are not at all clear what to do. Either supporting or opposing. Learned counsel for the state as well as the counsel for the respondent was opposed the writ petition, opposed the writ appeal. However, the learned counsel appearing for the respondent number seven has submitted that he is not affected by the order passed by the learned single judge, and therefore he has nothing to offer. Having heard the learned counsel for the parties, and after going through the material available on record, we are of the view that when the provincialization of the appellant was not under challenge in the writ petition filed by the appellant, filed by the respondent number one, there was no occasion for the learned single judge to set aside the said provincialization, that too without providing any opportunity to the counsel. What we have written? That too, now, to examine the examine the matter of provincialization of the appellant. Full stop. It is also to be noted, it is also to be noticed that pursuant to, it is to be noticed that this court, wide order dated 8/5/2024, has stayed the order of the learned single judge to the extent of setting aside the provincialization of services of the appellant, while clarifying that the state level scrutiny committee is free to proceed with the representation, if any, filed by the respondent number one. Full stop. It is informed that the pursuant to the order passed by the learned single judge, the respondent number one has preferred and representation
Can appeal. Can appeal.
an appeal before the state level scrutiny committee. However, the said appeal has been dismissed and the appellate authority has again recommended for provincialization of the appellant. Full stop. In view of the above, we are of the view that the order passed by the learned single judge of setting aside, to the extent of setting aside the provincialization of the appellant is not liable to be sustained. The same is therefore interfered with. The same is therefore set aside up to that extent. The appeal is disposed of. However, it is made clear that the respondent number one, yeah, needless to say that the respondent number one, if aggrieved by the order passed by the state level scrutiny committee dated 26th of November 2024, he is free to avail appropriate remedy available to him under the law.
Look, just one request, my lord. Although my lord had stayed the order of cancellation, my lord, till date he's been not paid salary. When being asked, my lord, he said there's no order of paying
There is
salary.
a separate claim, please.
Deeply obliged. I'm very grateful.
We are not going to.
Item 12.
My lord, an appeal by the state.
Yes,
This is an appeal by the state, my lord. If lordship has the list of dates which I have given just below the synopsis.
item number 14,
12, my lord, 12.
12.
The list of date lordship has below the synopsis. It is only the date of list of dates.
Increase here. The scale is 45%. Both the field and the field. Corporate areas are better. Even though it's not- even it's the same in the- we need to get- economy is better. But also, the- the withdrawal rate. Petition
Yes.
No, the petitioner had participated in the selection process. After the results were declared, the appointments were made on the 5th of February 2021. Till that point of time, the petitioner had no grievance. He did not.
There was no question of grievance because the clarification issued later on.
It was issued much later on after the entire selection process has been concluded. On the judgment of this honorable court coming in a different matter. Thereafter, the writ petition was preferred.
So that judgment in the different matter was challenged before the. by
There
the
are
state.
reviews pending and the appointments.
Reviews pending.
Reviews are pending and we are directed not to proceed with the appointment part. That has been done because we have come up with grounds.
That,
In this,
in the review petition, there is a stay order.
not dictated to the court, but we were told that when contempts come up, you just point out the order and you need not proceed with it right now. That is how the matter stands
Get
as of
that
now.
review petition decided.
But here, my lord, the only situation that would arise is,
Get that review petition decided.
but when they did not raise an objection to that particular, what happened in those writ petitions, the moment the advertisement, the other advertisements came, it was not the same advertisement, it was other advertisements. Those persons, they challenged it.
The learned single judge interpreted that clarification clause.
No, I'm not on the clarification part. What I am on is having participated without raising an objection to that clause, allowing the entire selection
Once
process
the
to
learned
conclude.
single judge has come to the conclusion that it is retrospective in nature, all thing is open.
That would have been had she had a, but I'm just trying to place that it's a case of offense, my lord. Waiting for someone else to fight on that particular ground, getting a result and then saying, no, they got it and I come back now to say that. It was after nearly a year of that writ petition having been, the selection process having concluded, that this writ petitioner approaches the court, saying that I should have got a chance on that. Her rejection was known to her in September 2020. She did not challenge the rejection at any point of time. The results were declared, she did not challenge it. The appointments were made, she did not challenge it. Was
When she have filed this petition?
my lord, the advertisement came on 11/9/2020. Appointments were completed on 5/2/2021. 20/2/2021, the clarification came, and 18/11/2021, the petitioner filed this writ petition. 7 months after the clarification came. Prior to the clarification itself, the entire selection was concluded. That is the only thing we are trying to test. Her rejection was in the month of September 2020. She was not aggrieved by the rejection. She is taking an advantage of a judgment which came later on. That is the only thing. If Lordship decides otherwise, suspicion matter. Right?
So in that writ petition,
My lord.
whether they have implemented those persons who have been
No,
selected as party.
none was implemented. And in fact, in the affidavit in opposition, we had made the statement that 5/2/2021, the appointments have been made, the selection proceeding is closed. That is there's a statement in the affidavit in opposition. But no parties were made. So now we have to pick out someone, because
although there was an interim order in November 2021, when he moved the writ petition, that one post, if it is there, be kept vacant. By the time the entire selection process, the second selection was completed. That is the only position.
Yes.
The day when the writ appeal was moved, your lordship will find that while saying the operation of the state is judgment, one post was kept vacant for me.
Is there was any post?
Huh?
Post, there
Because
was
on
post?
the date of filing of the writ petition, one post was there.
Selection is over by that time.
When I am arguing, then let him argue. I will speak.
We are asking you,
I
sir.
apologize.
My lord, I will place it, what the department has called upon before the law and signature. I will place those facts with you or not. Page 718, 11. Sorry, but as per page 115,
Impugned judgment,
impugned judgment,
para,
para 23. Impugned judgment, para 23.
That is the earliest.
My lord, where they have argued, these things were never before launching the judge. They have not argued anything about all this. That there is no post, one post was not lying, there they are the fence seeker. Nothing was argued on that way. Nothing was argued. How they come up with a new case before?
where they have not argued.
My lord.
In
My lord,
which case they have not argued.
my lord, they have not argued anything about that. That there was a fence seeker, there was no post lying during that time. My lord, all
Before
the
the
time,
learned single judge.
you the last thing is judge.
Where is that?
Para 23 onward.
That is some other.
Para 23 of
The judgment of the learned single judgment.
Sir, impugned judgment, para 23 is not there.
My lord, in our copy given by them, my lord, is there. My lord. Page, it starts with 109.
Sir, it's only 22
My lord, in our,
paras of 22.
my lord, here it is para 23. It is there, my lord.
Sir, kindly see, this writ appeal is
Agro
against the
judgment to say, Kishore judgment to page. Herit arm hoise. 130. Page 130 arm hoise.
Starts at page 130.
130.
130.
Yes, starts at 130.
The impugned judgment is 130, sir.
130. Sorry.
Ah. It contains only 22 paras.
My lord.
There is no
Para
para
11. Sorry, ma'am.
Huh?
Para 11.
Para 11. Yeah, what do you want to say?
On the basis of the state office memorandum, the responding secretary education department stated the conditions stipulated therein was strictly followed. It was mentioned that going through the record, it was seen that the date of birth of the petitioner belongs to AC category was certain, and the petitioner acquired the trade after 40 years of age. As such, the petitioner was not selected during the selection process. Held in respect of the advertisement in 1911-2020, further mentioned that only on 22-21, the first sentence of the sentence mentioned in paragraph 3 of the memorandum dated, the relaxation shall be applicable only to the candidates who have attained necessary educational or other qualification prior to working of the existing upper age limit of 40 years was omitted. It was further stand of the respondent secondary education department that the exercise of filling of the vacant post of it graduates in response to advertisement has been finalized for the subsequently appointment letters were issued. With the issuance of correction done, the government of Assam department. This is what we are contemplating. That much is the contention. Fence seater and others were not there. And again, at para 13, my lord, you will also will find. Para 13.
Yeah.
My lord, then submits that the settled position has to get the benefit of required to eligible on the date of initiation of recruitment process and the process in this case was initiated by the date of advertisement. The land standing was therefore submit that even taking the ultimate date of submission of application. However, the petitioner would not be eligible as admitted, the state qualification required after the secretary. Understanding of the further submit the function would have been restricted. Effect only cannot be given in respect to understanding then let us then these are the submissions before the fence seekers and nothing was discussed. Yeah, I get. It's been for so long. Thank you.
And because one post was lying vacant, there was no submission to the single judge that those posts are filled up. No post was lying vacant.
They have specifically said appointments have already been made.
Appointments have been made, whether they have stated that one post when the direction was there.
Sir, even though if their posts were already there, whether you can maintain a writ petition without impeding the persons who are likely to be affected.
Well, my lord, in one of the judgment of 2012 GLT, where a division bench of this court held, if an institution or a department is going for a selection, it's not always necessary, because if I don't directly attack to their appointment.
The direct this implication of this judgment is that they have to remove some person
Or my lord,
who has
that is
already
why
been
I-
selected.
That is why I am placing, if that post was lying vacant, they could fill me over there.
Even though if the post is lying vacant, then also suppose tomorrow they'll offer you the appointment, then you will ask for seniority amongst the selected person.
That chapter,
That-
as if your lordship in the last case has held, that is a matter which will go for a separate writ petition. Herein before this writ petition, it is not there.
How this last case, how
Last
you are
case
applying
also,
to last
they have
case?
asked for, when that was not challenged, and they want for the salary, your lordship will that will be a separate writ petition. If they are asking for that, they will go for a separate writ petition. They will challenge over there. And before the advertisement ballot, I qualified for that, and that there was a when. And that was white document. Only other cases before me, before there was because there was a mistake committed by them, so they have wiped up that ballot. And it was prior to the recruitment process, I have qualified, and from 14 to 19, the government has not gone for the state qualification. From 14 to 19, they have not gone for. Had there been a qualification examination, I would have applied for that. The moment that application was there, advertisement, I applied and I qualified for that. And prior to the recruitment process, I have qualified for that. And the direction from the single judge was
Sorry, have you filed a rejoinder to the affidavit filed by the?
during that time, I was not there.
There is no rejoinder, Mr.
Maybe if it's not there in the document.
All records are there in the writ appeal itself.
My lord, only thing what the honorable judge has done, they have set aside my rejection order and only directed that I may be considered in pursuance to the merit list where I have said. That was the reason. That
Or
was
kya denge, sir? Or what else the learned single judge should have ordered for?
the rejection
What
of my,
else?
setting aside of my rejection order. Whether the rejection was correct or not, that was to be decided by the learned.
and then to offer your appointment as per your merit,
As per my memory.
again reassessing the merit. They have to.
Well, what your lordship has pointed out me that whether all the elected candidates are to be a necessary party.
Not all the selected candidates, at least the persons who are standing below in the merit list.
My lord, at least, my lord, here, what I will just rely upon only one on division bench judgment. I asked my friend to bring that book, my lord. A division bench judgment where it was regarding the Manipur Public Service Commission. Justice Amitabh Roy and Justice Indira Shah had passed the judgment in para 20 that it's not necessary always. If you are not affecting them, my lord, it is not necessary to impede all the parties.
Yes, not affecting them, there is no necessity. But yes, if they offer you the appointment.
My lord, here, my another question is this, in the merit list, when one says.
Totally, you just let that. Tomorrow, if any other person came there, apart from this respondent, some other person also came there, because since this judgment was there, that was a clarificatory note and it always applicable retrospectively. I was also not having that within that time. But since this condition is abolished, now you offer me appointment after 5 years, 6 years, 10 years. We have to ask them.
My lord,
We have to give the same relief.
my lord, here, the judgment can be said to be only in relation to this because it was from the date of the writ petition, from the starting of the writ petition, the interim order was there to keep one post vacant. Neither they have come for setting aside of that or modifying of that order, or they have not said that during the time of hearing that those posts have been, there is no such post. Only they have stated that all the appointments were given. Whether that only on the other side it resembles that at least one post was kept giving others as appointment. So that
Suppose then they're not required to remove any person from service. You tomorrow you'll enter into the service. You are naturally you're senior to those persons who have already been selected as per your merit. Then you will ask for seniority. And who is going to affect it?
Well, during that time, if they are affected, they will come and you have to make them a party.
So at that time we'll grant them hearing, otherwise not.
Mala, if all the select list candidates.
So whatever the rights accrue to a person likely to be affected, then that person is required to be made as a party, sir.
Yeah, the thing is this, my lord, where a person is very difficult for a day to now get a job. After I get selected, and in the merit condition for technical ground that a person is on the list below me and not been asked to come before this court. Was it not the duty of the department also to do certain things?
No, sir, not at all. The person who has approached the court, it is his duty, sir.
My lord, it is my duty also there, but they have to also say before the court that that post was not lying vacant. We have filled up that.
Even though if the post is lying vacant, then also your entry into the service at
I don't know whether my client
is likely to affect the.
Whether my client will come for seniority or not, that is a subsequent, whether he will survive or not is a subsequent. Well, for that reason, my lord, I will be not given an appointment where I am selected, a person below me. So the merit condition will never be taken into consideration.
That is not.
And when that qualification criteria has been removed by them, only on technical ground that you have not made them a party, you are a fence sitter, which are not argued before the learned single judge, and your lordship will interfere and set aside the election, my appointment.
Then my appointment to this, still they have not.
I will rely upon because.
Just say one thing, my lord, with permission.
No,
She was never selected, my lord.
But
There was no selection.
But as per the merit list. If I was not selected, then they would have said before that, my lord, that you are not selected by an affidavit.
yes, yes, Mr. Majid.
They have given a select list at page 73. They have attached the select list. Her name is not there. She was never a selected candidate. So the selection party was never there. She got rejected on the document verification, age verification. She did not object to it at that point of time. That is what it means.
Is any law point on?
The fence sitters law, my lord, I'm not carrying with me right now, but that is certain law, my lord. She waited for the outcome.
That's all.
My lord, as regards making including everybody in
Yeah.
2012 to GLT para 893 para 20.
Yeah. What did it say?
Some of the Marat I have because one page you marked about there in para 20 just to get the meaning of those words using the judgment.
Necessary party. Selected candidate necessary party, sir. Yes, sir.
And my lord, if you permit me to say, they have not argued that. What I want to place is clarify, my lord, the explanations are always generally retrospectively. So what they have clarified that it will not be applicable, my lord. That will be retrospectively.
Oh, we are not much on that. We are not, we are not much on that.
Their only thing that I'm a fence sitter and my lord, I have not made everybody up.
We are not on much on that. Maybe the view expressed by the learned single judge or that clarification always retrospective may not be that incorrect. That you are not challenged much.
In this repetition, we have not challenged it, but
That may be-
otherwise, my lord, we.
Otherwise, it's okay. That's all.
I'm sorry, my lord, if I've done something wrong in my speech.
No, no, sir, please, it's your duty. So we are not taking. How did it come there? What is it?
Lordship, the judgment of Pensita, my lord, recent one, 2021 judgment is there.
Photocopy.
Photocopy ले आएगा. Citation to me.
Mentioning the relevant para and all.
Man.
Photocopy.
Because that my judgment of
At lunch
GLT,
only.
my lord, it is not there in the SPC. I have to find it out.
Which
That
one?
GLT judgment,
We have already noted.
that is not in the SPC format, so I could not get it.
No, will.
Item 14.
Voting chili. ये भी वही है.
Connected to terrace.
Connected.
Item 15.
Another bench. Sir, very nice. Why?
No, no, my lord is right, my lord. Similar matters. No, I didn't.
File appeals in those cases.
No, my lord, their review is pending and my lord has stayed the order in view of the stay passed in this. So, I was also thinking of that, my lord, morning. Obliged.
Item number 16 to 43.
Matt later. So in this series matter, the leading case that is WA number 287/2023
Yeah.
is not listed. My lord, may I pray, my lord, to list the matter along with,
The बात तो एक ही है. Leading case, even though if the leading case is not listed, one and the same thing.
my lord, that is the
Issue is the same.
issue is the same, my lord. It is the instruction from our, my lord, Advocate General. He will argue this series matters, my lord.
That is your advocate general.
My lord, he instructed me to, my lord, list the matter
Get it
after a week
adjourned.
along with this, my lord, matter, my lord. That was the instruction, my lord.
क्या instruction?
Along with this matter. My lord, may I pray to accommodate for that day, my lord, next week, any day along with the, my lord, W number 287.
Counsel for the respondent. You are appealing.
We have some appeals because interim order is operating in this case.
You have to answer many questions. You have to answer many questions.
Yes.
And this scheme is already that close for compassionate appointment. How this court can grant this order there that no, despite this closure of the scheme, grant them appointment? even though it's 3 years or not. Even though you have challenged that memorandum of 2015. 15, 10 years have passed. As per the Supreme Court judgment, they were Trivedi, whether appointment can be offered to you. These are many things you have to answer that. Not only this. Even though this judgment may or may not be, we may appeal this judgment, despite that, what relief you will get? Urgency, you are showing urgency is there, what relief you will get?
Subsequent when that application was
In some of the cases, the death of the date of death of the employee was 2009.
maybe some
Maybe some person then, it was 2007. 18 years.
So all the cases are not
Not all the cases. 10 years of high. 8 years. 8 years. Minimum 8 years. After the 8 years, whether this appointment can be offered under the compassionate appointment. And this application of Article 14 is also doubtful in cases of compassionate appointment. Where is the question of application of Article 14, sir? How the Article 14 comes into play? There is an exception to the general rule. In that, there are certain situations you have to answer many questions also. Okay. Be prepared or ready to argue today itself. Now you'll seek time. Yes, any other date. Be prepared. You also both. Which one? Which matter? Your
My lord, WA number 287, 2023.
2020.
23.
23. Okay, in item number this 10 and 10, 14, and then 16 to
Then 17 to my lord, last one, my
16.
16 to
43.
education.
In all these matters, learned
43.
counsel for the appellant has submitted that these writ appeals be listed along with the lead case writ appeal number 287/2023 on 8th of April. Okay, any day after BU vacation, then in the first week of June. Lagao. There is no urgency.
Passover 7.
Amla Ismail.
Passover 7.
Item number 7, my lord. My lord, taking order pursuant to the, my lord, direction of the learned single judge has already been passed. It is awaiting for the approval of the law minister.
What is the speaking order?
That speaking order has not been communicated because of, my lord.
Whether you have rejected our claim, accepted our
That,
claim.
my lord, because, my lord, it is not.
Approval of the education minister is, what is this? Business of approval of the education minister, it is.
Only two accommodation, my lord, thereafter, my lord, place the order, whatever.
Nikhil and concept for the state has submitted that. As a matter of fact, the respondents have already examined the claim of the appellant pursuant to the direction given by the learned single judge. However, no final order has been passed as the same is awaiting However, the speaking, no speaking order, however, the speaking order passed in the matter is awaiting approval of the concerned minister. He plays 2 weeks time, list after 2 weeks. And council for the state करना है. That's all.